domestic violence, harassment, child, sex trafficking,
Anti-Violence Against Women and Children. Republic Act 9262, the Anti-Violence Against Women and Their Children Act of 2004. The state values the dignity of women and children and guarantees for respect for human rights. The state also recognizes the need to protect the family and its members, particularly women and children, from violence and threats to their personal safety and security. Violence against women and their children refers to any act or a series of acts committed by any person against a woman who is his wife, former wife, or against a woman with whom a person has or had a sexual or dating relationship, or with whom he has a common child, or against her child, whether legitimate or illegitimate, within or without the family abode, which result in or is likely to result in physical, sexual, psychological harm or suffering, or economic abuse, including threats of such acts, battery, assault, coercion, harassment, or arbitrary deprivation of liberty. Forms of violence, act of violence against women and their children, physical violence, sexual violence, psychological violence, and economic violence. Physical violence refers to acts that include bodily or physical harm, is committed through threatening, attempting, placing, causing physical harm to the woman or her child, inflicting or threatening to inflict physical harm on oneself for the purpose of controlling her action or decision. Sexual violence refers to an act which is sexual in nature, committed against a woman or her child. It includes but is not limited to rape, sexual harassment, act of lasciviousness, treating a woman or her child as sex object, making demeaning and sexual suggestive remarks, physically attacking the sexual parts of the victim's body, forcing her or him to watch obscene publication and indecent shows, forcing the woman or her child to indecent act and or make indecent. Psychological violence refers to acts or omissions that cause mental or emotional suffering, is committed through conduct that causes alarm, emotional or psychological distress to the woman and her child, intimidation, harassment, stalking, damage to the property, public ridicule or humiliation, repeated verbal abuse, and marital infidelity. Psychological violence, allowing the victim to witness the physical, sexual, or psychological abuse of a member of the family to which the victim belongs, destroying property, inflicting harm to pets of the woman, engaging in any form of harassment or violence, causing mental, emotional anguish to the woman, unlawful or unwanted deprivation of the right to custody and or visitation of common children. Economic violence refers to act that make or attempt to make a woman financially dependent, is committed through threatening, attempting to deprive the woman custody of her child, financial support, legal right, withdrawal of financial support, preventing the woman to engage a legal profession, occupation, business, controlling the woman's own money, properties, or solely controlling conjugal or common money or properties.
Gender violence may suffer from different human rights violations. For example, the right to life, freedom from torture and degrading treatment, freedom from discrimination, and the right to safety and security. Also, gender-based violence violates fundamental human rights and is a major barrier to achieving gender equality. The UN regards violence against women as one of the most significant violations of women's rights across the world. Women are entitled to the full and equal enjoyment of their human rights, free from discrimination, and all workers, regardless of immigration status, have the right to protection and redress from sexual harassment and other workplace abuses. Crucial to addressing these issues in the workplace are a range of international labor standards that are relevant to preventing and eliminating gender-based violence at work.
Why is violation against women a big issue nowadays? Violence against women and girls is a hidden global crisis that knows no boundaries of geography or culture. But marginalized women, such as poor women and girls, are most likely to experience it, most often at the hands of their husbands or partners. It is one of the most widespread violation of human rights and has long-term devastating effects on the lives of women, their communities, and wider society. It is time to say, enough is enough. We want violence against women to end. How can we end violence against women? Violence against women is preventable. Research shows the vital work of independent women's rights organizations is the single most effective way to create the real change that will bring down violence against women. Create laws and enforce existing laws that protect women from discrimination and violence, including rape, beating, verbal abuse, mutilation, torture, honor killings, and trafficking. Educate community members on their responsibilities under international and national human rights laws.
Anti-sexual harassment.
Let's talk about RA 7877, Anti-Sexual Harassment Act of 1995. An act declaring sexual harassment unlawful in the employment, education, or training environment, and for other purposes. Conduct of sexual nature: verbal, visual, physical. Verbal harassment: sexual stories, sexual rumors, sexual jokes, requesting for sexual favors, or repeatedly asking a person out. Visual harassment: malicious staring, posters, drawings, pictures, emails, or texts of sexual nature. Physical harassment: inappropriate touching, rubbing, impeding or blocking of movement, sexual gestures. Consequences of sexual harassment: disciplinary actions, written warnings, suspension, demotion, even termination. Lawsuits. Prevention of sexual harassment: be knowledgeable about anti-sexual harassment. Report when you see or hear it. Treat everyone with respect.
Sexual harassment. The Act clearly defines what constitutes sexual harassment. It includes any unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature that creates an intimidating, hostile, or offensive environment. Protection for victims. The Act ensures that victims of sexual harassment are protected from any form of retaliation. It prohibits employers or educational institutions from taking any adverse action against the victim for reporting the harassment or participating in an investigation. Number 3. Complaint mechanism. The Act establishes complaint mechanism to address sexual harassment case. It requires employers and educational institutions to establish procedures for lodging complaints, conducting investigation, and taking appropriate action against the harasser. Number 4. Liability of employers and institutions. The Act holds employers and educational institutions responsible for preventing and addressing sexual harassment. They are required to take proactive measures to prevent harassment, provide awareness and training programs, and take prompt action upon receiving a complaint. Number 5. Penalties and remedies. The Act imposes penalties for individuals found guilty of sexual harassment. It also provides remedies for victims, including monetary compensation, injunctions, and other appropriate relief. Number 6. Awareness and education. The Act emphasizes the importance of awareness and education regarding sexual harassment. It requires employers and educational institutions to conduct regular training programs to educate employees and students about their rights, responsibilities, and the consequences of sexual harassment. Number 7. Confidentiality. The Act ensures that the identity of the victim and any information related to the complaint are kept confidential to protect the privacy and dignity of the victim. Overall, the Anti-Sexual Harassment Act plays a crucial role in preventing and addressing sexual harassment by providing clear definitions, protection for victims, a complaint mechanism, liability for employers and institutions, penalties, remedies, awareness, and confidentiality provisions. These provisions work together to create a safer and more inclusive environment where individuals are protected from the harmful effect of sexual harassment.
Anti-rape law.
In 2018, at least one woman or child is raped every 72 minutes in the Philippines. The number of rape cases reported in the country continues to rise in the following year, with a 30.6% increase in 2019 compared to 2018. And in 2020, at the height of COVID-19 lockdowns, an average of 18 people were raped every day in the country, with a total of 3,016 cases of sexual assault reported from March 17 to August 31, 2020. This data prove that rape remains a prevalent social problem in the Philippines. This is despite the existence of the law that punishes people who commit rape crimes. The Republic Act No. 8353, or the Anti-Rape Law. What is Republic Act No. 8353, or the Anti-Rape Law? Anti-Rape Law of 1997 is the short title for an act expanding the definition of the crime of rape, reclassifying the same as a crime against persons, amending for the Purpose Act No. 3815 as amended, otherwise known as the Revised Penal Code, and for the purposes.
Let's talk about the various punishments for committing rape. First is reclusion perpetua to death or life imprisonment. It is stated in the first paragraph of the article that this penalty shall be imposed whenever the rape is committed with the use of a deadly weapon or by two or more persons. When by reason or on the occasion of the rape, the victim has become insane. When the rape is attempted and the homicide is committed by reason or on the occasion thereof. When by reason or on the occasion of the rape, homicide is committed. The death penalty shall also be imposed if the crime of rape is committed with any of the following aggravating or qualifying circumstances. When the victim is under 18 years of age and the offender is a parent, ascendant, step-parent, guardian, relative by consanguinity or affinity within the third civil degree, or the common law spouse of the parent of the victim. When the victim is under the custody of the police or military authorities or any law enforcement or penal institution. When the rape is committed in full view of the spouse, parent, any of the children or other relatives within the third civil degree of consanguinity. When the victim is a religious engaged in legitimate religious vocation or calling and is personally known to be such by the offender before or at the time of the commission of the crime. When the victim is a child below 7 years old. When the offender knows that he is afflicted with the human immunodeficiency virus and acquired immune deficiency syndrome or any other sexually transmissible disease, and the virus or disease is transmitted to the victim. When committed by any member of the Armed Forces of the Philippines or paramilitary units thereof, or the Philippine National Police, or any law enforcement agency or penal institution, when the offender took advantage of his position to facilitate the commission of the crime. When by reason or on the occasion of the rape, the victim has suffered permanent physical mutilation or disability. When the offender knew the pregnancy of the offended party at the time of the commission of the crime. And when the offender knew of mental disability, emotional disorder, and or physical handicap of the offended party at the time of the commission of the crime. However, then President Gloria Macapagal Arroyo abolished the death penalty by virtue of the Republic Act No. 9346, or an act prohibiting the imposition of death penalty in the Philippines in 2006, reducing maximum punishment to life imprisonment. On the other hand, on the second paragraph of the article, prison mayor de reclusion temporal shall be imposed whenever the rape is committed with the use of a deadly weapon or by two or more persons. When by reason or on the occasion of the rape, the victim has become insane, the penalty shall be reclusion temporal. When the rape is attempted and the homicide is committed by reason or on the occasion thereof, the penalty shall be reclusion temporal to reclusion perpetua. When by reason or on the occasion of the rape, homicide is committed, the penalty shall be reclusion perpetua. Reclusion temporal shall be imposed if the rape is committed with any of the 10 aggravating or qualifying circumstances mentioned in this article.
The important provision of anti-rape laws vary from country to country, but there are some common elements that are generally considered crucial in reducing and preventing sexual violence. Here are some important provisions commonly found in anti-rape laws. Number 1. Definition of rape. Anti-rape laws typically provide a clear and comprehensive definition of rape, including non-consensual sexual intercourse or penetration, regardless of the gender of the victim or the perpetrator. This definition aims to ensure that all forms of sexual violence are covered under the law. Number 2. Consent. Consent is a fundamental aspect of anti-rape laws. These laws commonly emphasize the importance of obtaining explicit and voluntary consent from the victim before engaging in any sexual activity. They often define the constitute valid consent, such as the absence of coercion, threats, or incapacity due to intoxication or age. Number 3. Age of consent. Anti-rape laws also establish an age of consent, which is the minimum age at which a person can legally give consent to engage in sexual activity. This provision aims to protect minors from sexual exploitation and abuse.
Marital rape. Many jurisdictions recognize that rape can occur within marriage or intimate relationships. Anti-rape laws has provisions that criminalize marital rape, ensuring that spouses are not exempt from prosecution for sexual violence against their partners. Number 5. Gender neutrality. Modern anti-rape laws have increasingly adopted a gender-neutral approach, acknowledging that both men and women can be victims of sexual violence and that both men and women can be perpetrators. These provisions help ensure that all victims are not protected and all perpetrators are held accountable regardless of their gender. Number 6. Punishments and penalties. Anti-rape law establish appropriate punishment and penalties for offenders. These may include imprisonment, fines, mandatory counseling or rehabilitation programs, and registration as a sex offender. The severity of the punishment often depends on factors such as the age of the victim, the use of violence, and the presence of aggravating circumstances and the prior criminal record of the perpetrator. Number 7. Victim protection and support. Anti-rape laws often include provisions to protect victims and witnesses, ensuring their privacy, confidentiality, and safety throughout the legal process. They may also provide access to medical, psychological, and legal support services for victims, including counseling, medical examination, and legal representation.
Number 8. Reporting and investigation. Anti-rape laws establish procedures for reporting sexual violence and ensure that law enforcement agencies promptly and effectively investigate such cases. They may require specialized training for law enforcement personnel and establish protocols for handling rape cases to minimize re-traumatization of the victim. Number 9. Prevention and awareness. Many anti-rape laws emphasize the importance of prevention and awareness programs. This provision may include educational campaigns, workshops, and training programs aimed at promoting consent, challenging harmful gender norms, and preventing sexual violence in schools, workplace, and communities. It is important to note that the provisions mentioned above are not exhaustive, and anti-rape laws can vary significantly between countries. However, the common goal of these laws is to protect victims, hold perpetrators accountable, and prevent sexual violence in all its forms.
Laws and cases involving rape can vary significantly by jurisdiction and evolve over time. To analyze specific cases involving anti-rape laws, you should consult legal databases, news sources, or contact a legal professional for the latest and most accurate information on such cases. Also, the anti-rape cases refer to legal actions taken to combat and prosecute cases of sexual assault or rape. These cases typically involve law enforcement agencies, legal authorities, and support service for survivors.